I wanted to speak with you today about the impact of the COVID-19 crisis upon financial hearings taking place in the family court. Prior to the current crisis, these hearings used to take place on a face-to-face basis within the court building. However, the starting point now is that these hearings should be taking place remotely. But the reality is that the court is facing a number of challenges at this time. It has limited resources, and it simply cannot list the same number of hearings to take place remotely as it would if they were taking place within a court. As a result, they're having to prioritise the hearings that they do list, and our experience locally is that significant numbers of financial proceedings are being adjourned. So what are the options available to you if you're concerned that your hearing is going to be adjourned or it has been adjourned? Well, it's necessary to look at where you are in the financial process. If you're coming up for the first hearing, known as the first appointment, then it may be possible to agree with the other party what directions need to take place in order for your case to progress. If that's possible, you can submit an agreed order to the judge and ask the judge to approve it without a hearing taking place. Where it's not possible to agree what needs to take place, then it may be possible for both of you to submit written reasons as to what you want to take place and why. The judge can then look at these and determine the issue on paper without a hearing needing to take place. If your case is listed for the second hearing in the process, known as the financial dispute resolution hearing, then I think it's really important to look at your current circumstances. The purpose of an FDR is to allow parties to be able to negotiate with input from a judge on a without prejudice basis. However, there may be legitimate reasons why, due to the current circumstances, you don't feel in a position to be able to have effective negotiations. There's naturally going to be a concern from the court that people will use this current crisis as an excuse to delay matters. But I don't think it would be right for us simply to adopt the approach of ploughing on regardless. Individuals need to look at their circumstances and consider whether there is a legitimate reason as to why they cannot engage in effective negotiations. If that is the case, then in my view, that needs to be taken into account of. Whether a judge or a court would agree that that reason is a legitimate reason not to proceed is a different matter, but certainly it should be given some consideration. However, where you feel that you are able to proceed with an FDR, then there's the option of having a private FDR. That's where you would instruct an experienced family barrister or solicitor to take the role as the judge. The benefit with these hearings is that they can take place on the convenience often of the parties for a date which suits them, and that they can make use of technology to enable them to go ahead during the current crisis. If your hearing has been listed for a final hearing and you're concerned that that hearing may not go ahead, then there's the option of using a process called arbitration. Arbitration is where you would instruct an arbitrator to take the role of a judge. They can then make a binding determination upon both the parties. These, again, as with a private FDR, can often take place at the convenience of the parties and can make use of technology to allow them to take place even during the current crisis. Ultimately, there are still options to allow matters to progress in appropriate cases. It's a case of working out which option is most appropriate in your circumstances.